Australia's banking and finance sector is in line for a shake-up, and a number of its executives could face criminal charges. A year-long public inquiry found that banks had committed a range of misdemeanours, ripping off consumers for years. Luke Schrago explains.
Charging dead customers finance fees, charging for services not provided, selling inappropriate products to the vulnerable, and bribery for mortgage business. Just some of the evidence given in an 11-month inquiry that's left the Australian finance sector's reputation in tatters.
It's a scathing assessment of conduct driven by greed and behaviour that was in breach of existing law. The price paid by our community for this misconduct is immense.
The government-commissioned inquiry referred 24 instances of misconduct to regulators for further investigation and potential prosecution. It also made 76 recommendations, on all of which the government said it would act, including establishing a compensation fund to help those who lost out on bad financial advice, closing legal loopholes and increasing consumer protections. Anticipating closer scrutiny, banks have been tightening up their act in recent months.
Banks understand that these failures have caused deep hurt, suffering and heartache. Banks accept full responsibility for these failings, and they know that they must now change to ensure that this never happens again.
The inquiry, however, didn't go as far as recommending punishments or splitting up a sector worth $291 billion, leaving such decisions to regulators, who themselves have been accused of working too closely with banks. Whatever the Australian government decides to legislate, though, there's not much time for them to do so. National elections are due in just 4 months.